Faites l'appel, s'il vous plaît, Madame le greffier.
Monsieur le connétable de Saint-Hélier. Madame le connétable de Saint-Laurent.
Présente.
Monsieur le connétable de Saint-Brelard.
Présent.
Monsieur le connétable de la Trinité.
Présent.
Monsieur le connétable de Saint-Pierre.
Présent.
Madame le connétable de Saint-Martin.
Présente.
Monsieur le connétable de Saint-Jean.
Présent.
Monsieur le connétable de Saint-Clément.
Présent.
Monsieur le connétable de Greville.
Présent.
Monsieur le connétable de Saint-Baume.
Présent.
Monsieur le connétable de Saint-Marie.
Présent.
Monsieur le connétable de Saint-Sauveur.
Présent.
Monsieur le deputy Southern.
Présent.
Madame le deputy Labbé.
Présente.
Monsieur le deputy Tadier.
Présent.
Monsieur le deputy Luce.
Présent.
Madame le deputy Doublé. Monsieur le deputy Morel. Madame le deputy Lehegera.
Présente.
Monsieur le deputy Iron.
Présent.
Monsieur le deputy Ward.
Présent.
Madame le deputy Alves.
Présente.
Madame le deputy Gardner. Monsieur le deputy Gorse.
Présent.
Monsieur le deputy Farnham. Madame le deputy Moore. Monsieur le deputy Mezek. Monsieur le deputy Balash.
Présent.
Monsieur le deputy Coles.
Présent.
Madame le deputy Corray.
Présente.
Monsieur le deputy Wall.
Présent.
Madame le deputy Miles.
Présente.
Madame le deputy Scott.
Présente.
Monsieur le deputy Renaud.
Présent.
Madame le deputy Curtis. Madame le deputy Feltham.
Présente.
Madame le deputy Binet.
Présente.
Madame le deputy Jeune. Madame le deputy Miller.
Présente.
Madame le deputy Howell.
Présente.
Monsieur le deputy Binet. Monsieur le deputy Ferry.
Présent.
Madame le deputy Kovac.
Présente.
Monsieur le deputy Curtis.
Présent.
Madame le deputy Ward.
Présente.
Madame le deputy Wilson.
Présente.
Madame le deputy Stevenson.
Présente.
Monsieur le deputy Andrews.
Présent.
Monsieur le doyen.
Notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et les puissances de la terre, pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, de la conduire tellement toi-même par ton Saint-Esprit, que toute leur délibération est accompagnée de ta bénédiction. Réussisse au bien et au jugement du peuple qu'il t'a plu de commettre à leurs soins. Car nous t'en prions au nom et par les mérites de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, bien sûr, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite sur la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonnons nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie pas en tentation, mais délivre-nous du mal. Car à toi est la règne, la puissance et la gloire, au siècle des siècles. Amen.
Madame le deputy Doublé.
Présente.
Monsieur le deputy Morel.
Présent.
Monsieur le deputy Farnham.
Défait.
Madame le deputy Moore.
Défait.
Madame le deputy Jeune.
Please may Deputy Jearn be marked excusé because she's taking a family member to a medical appointment in the UK.
I'm just content to mark the deputy excusé. Excusé.
Thank you.
Les états sont constitués. Connétable of St Peter.
Sir, I was wondering if I might ask just to make a change to the order. I'm presenting P88, and I would like, if possible, to then present P105, which is currently the last item of the sitting. If I could do that immediately afterwards, simply because I would like to attend to some parish matters, if possible, this afternoon. I'm on a flight to the UK tomorrow and then to Australia, so I sort of have to fit quite a bit in.
Yes. So P88 is
Yes.
the Draft Children Convention Rights Jersey Commencement Act,
That's right.
which in theory should be short. And then the last matter and the next matter you wish to raise is P105, the Draft Children and Civil Status Parental Responsibility Jersey Amendment Regulations. Those are the regulations you lodged late.
Yes.
You want them dealt with sequentially.
If I could.
Yes. Is the proposition seconded?
Yes, sir.
Does anyone wish to speak on the proposition? Members content to proceed as suggested by the Connétable.
Thank you, sir.
Thank you. So we now return to the draft Police Complaints and Conduct Amendment Regulations, P81, which we'd reached in third reading. And in my view, under Standing Order 103(2)C, in the circumstances, members may speak again in third reading. I think only 2 members did speak in third reading. The rest were questions to the Solicitor General. So I call upon the Minister in third reading.
Sir, at this stage it would be appropriate for me to answer the question which was asked of me yesterday. The question that Deputy Baloch asked was concerning the limitation of liability being provided for in new regulation 2A in brackets 2 being amended into the States of Jersey Police Force, Chief Officer and Deputy Chief Officer, Jersey Regulations 2017. While our policing legislation needs to be effective for Jersey, we share policing culture with the UK and have similar expectations of our police. So while we develop our own structures, when required in many areas, this new complaints legislation defaults to providing something comparable to the UK structure. In the UK, by virtue of paragraph 15 in brackets 1 of Schedule 1 of the Police Reform and Social Responsibility Act 2011, police and crime commissioners and their staff have protection from liability across all areas of their work, including any disciplinary actions they take in respect of a chief constable or assistant chief constable. So, in our new legislation, this liability protection is provided to our Police Complaints Commission by paragraph 6 of Schedule 1 of the 2022 law, and is also due to other parties who might be taking actions akin to those of the UK commissioners. As the panel considering the behaviour of the Chief Officer or Deputy Chief Officer, provided for new regulation 2A will have such a function. They are similarly protected from liability, just as the Commission staff are protected in the UK. So are the advisors to the panel in Jersey, including any human resources professionals who are mentioned in the 2017 regulations. The intention is simply to provide a comparable environment. However, after detailed review, I have been advised that the UK legislation does not extend liability limitation to legal representatives in the same way that the amended 2017 regulations will do here. If that is the source of the Deputy's concern, then I would be happy to agree to make an amendment to those regulations to remove such limitation at the earliest opportunity, which is a fairly minor matter and so hopefully could be at least, if not by the end of the year, pretty much within the first month of 2026, if this legislation can move forward now without being delayed. I do apologise to the Deputy for not being able to answer his question yesterday, and to the Assembly. These regulations are one of an extremely complex set of legislation which has been developed over the past 5 years. I am advised from a review of the files that the decision to include a limited liability was taken before August 2020 and has remained in these regulations ever since. This matter has never been raised before, either in connection with these amendments or the earlier police complaints law in the Assembly, at scrutiny, or indeed at the recent meeting members' briefings. So I do hope that members will understand why that I was not prepared for this answer yesterday. Thank you, sir.
Minister, just to understand your undertaking to the Assembly, just so I understand it properly, it's in relation to Regulation 5 of these regulations, the new Regulation 2A, or Article 2A, 1C, is it? It's simply that you're proposing to lodge an amendment which has the effect of removing the words "a person who is advising or has advised a tribunal under Regulation 2.5. Is that right?
Yes, sir.
Yes. Thank you. Does any other member speak on this matter in third reading?
Sir, could we raise the defo on Deputy Fund, please?
Members content to raise a defo on Deputy Fund? The defo is raised. Yes, Deputy Scott.
Sir, it was my understanding that the Solicitor General had been asked questions in relation to the effectiveness or actually need for this this wording, so I would be grateful if he could advise.
Mr. Solicitor?
Well, I think the topic has now become academic in light of the Minister's undertaking to remove lawyers from the indemnity. I can't see it will assist the debate in third reading for me to offer an entirely academic view on how, if at all, this indemnity would work in respect of a lawyer advising the panel who found himself being sued by a chief officer or deputy chief officer. I think we've moved beyond that now.
Does anyone else wish to speak in third reading on this matter? Deputy Balash.
So may I just express my thanks to the Minister for her comprehensive answer to my question, and to say that I'm entirely content with the way in which she proposes to deal with the problem.
Thank you, Deputy. Does anyone else wish to speak in third reading? I call upon the Minister to reply. Minister.
Yes, thank you, sir, and I thank the Deputy and members for their support yesterday. It was a challenging piece of question to answer, and we've managed to get there. Thank you. And I ask for the appel, sir, please.
That has been called for. Members are invited to return to their seats. I ask the greffier to open the voting.
Sorry, sir. Can I ask a quick question on this? So I'm trying to...
No, you can't.
I can't. Okay.
For members have the opportunity of casting their votes, I ask the greffier to close the voting. Announce that the regulation has been adopted unanimously in third reading, 45 votes for. The next item is the draft Complaints and Conduct States of Jersey Police Force Regulations lodged by the Minister for Justice and Home Affairs. The main respondent is the Chair of the Children Education and Home Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Police Complaints and Conduct States of Jersey Police Force Regulations 2000. The states make these regulations under Articles 81A, 96, 19.2, 3 and 4, 2010 and 22 of the Police Complaints and Conduct Jersey Law 2022.
Minister.
Thank you, sir. These regulations will provide a highly anticipated update to our current provisions for dealing with police complaints. It is worth just revisiting some of the background to this legislation. At the heart of any effective police disciplinary system lie these essential purposes. First, to maintain public confidence in our police service and to protect its reputation. Second, to uphold the highest standards of conduct and deter any form of misconduct. And third, to ensure the safety and protection of the public we serve. On the 30th of March 2022, we took a significant step forward by adopting the Police Complaints and Conduct Jersey Law 2022, which I'll refer as the 2022 law. This legislation marks a comprehensive and modern update to our approach to police complaints. Once enacted, this framework will bring Jersey up to date with modern expectations and best practices. The 2022 law provides a clear and structured foundation for how complaints should be managed. It also brings us closer in line with similar legislation across the British Isles, which is particularly important when we consider the potential need for mutual aid where resources and services may be shared across jurisdictions. The 2022 law sets out that dissatisfaction with the police falls into three areas: complaints about an officer's actions, conduct matters which where misconduct or criminal behaviour is suspected, and the most serious cases involving a death or serious injury linked to police contact. A complaint is a written expression of dissatisfaction about a police officer's actions submitted by those affected or their representatives. It must relate to harm or risk caused but cannot challenge a centennial's charging decision. A conduct matter arises when there is any sign of criminal behaviour or misconduct. If that threshold is not met, the issue can be addressed informally through agreed resolution, reflective practice review, or performance procedures. I will outline these in greater detail later. Serious injury or death refers to any case where a detained person dies or is seriously injured and there is an indication that police contact may have been a contributory factor. A notable feature of the 2022 law is the inclusion of designated persons. These are individuals who may be public employees assigned to perform police functions or employees of contractors designated under the Police Force Jersey Law 2012. All of these arrangements will be overseen by the Jersey Police Complaints Commission, the Commission, which replaced the existing Jersey Police Complaints Authority while retaining the same membership. The regulations will ensure that procedural process matters will be brought together in a single coherent framework. The focus of these reforms is on resolving matters easily, reasonably and proportionately. We are shifting the emphasis towards learning and development rather than punishment alone. This approach recognises that the vast majority of officers serve with honour and dedication, and that when issues arise, they should be addressed in a way that offers support and education. Where disciplinary proceedings are necessary, they will be conducted in accordance with the highest standard, reasonably, transparently, objectively and fairly. These principles are not just words, they are the foundation of a just and effective system. Importantly, the disciplinary procedures now align with best practices found in other employment fields, while still recognising the unique and vital role that police officers play in our society. This balance ensures that officers are treated fairly, while also maintaining the high standards the public rightly expects. Accountability will go beyond active service. It will also It will also apply to former police officers and former designated persons, providing that the issue was raised before or within 12 months of their departure. It is important to note that the Chief Officer and Deputy Chief Officer are governed by separate legislation, reflecting the unique nature of their leadership roles. Our objective is to ensure that complaint handling standards are consistently applied. This is not merely a matter of administrative efficiency, it is a matter of public trust. I will talk about the initial steps to be taken once a complaint is received. Written complaints about police officers go to the Chief Officer, who records the complaint, secures any evidence and informs the Deputy Chief Officer and the Commission. Copies are shared with both the complainant and the officer unless this would compromise an investigation or the public interest, and these decisions are reviewed regularly. If a criminal offence is suspected, the DCO must refer the case to the Solicitor General. The DCO may decide not to pursue a complaint or to adjust how it is handled, where it is clearly without merit, whether that's because it is unfounded, repetitive, anonymous, vexatious, or impractical to investigate. This can only be done with the Commission's agreement. This is particularly relevant where a complaint is over 12 months old and appears to lack any justification. In such incidences, the complainant will be informed of the decision and the reasons behind it, unless it's not practical to do so. These safeguards help ensure that the system remains fair and focused on matters that can be properly and meaningfully addressed. Where a complaint involves an unknown officer or designated person, the standard procedures such as notifying the person complained about or their opportunity to make a representation will not obviously apply. However, if the individual is later identified, the investigation may resume. The DCO also has the authority to suspend serving officers or designated persons, excluding former officers, if they are charged, reported for misconduct or subject of a complaint. We are also introducing a more effective approach to resolving complaints where formal investigation or criminal proceedings are not required. The previous informal resolution process is now replaced by the agreed resolution of complaints. In these circumstances, where outcomes such as dismissal, resignation, or formal warnings are not anticipated, a proportionate and structured process will be undertaken. This process will be overseen by an inspector or above, appointed by the DCO. Once concluded, the outcome will be formally recorded and submitted to the DCO for review and assurance. The complainant retains the right to request a review by the Commission if they are not happy with the outcome of the agreed resolution. Where the agreed resolution procedure is not appropriate, the DCO will assess whether the matter amounts to misconduct, gross misconduct, or neither. If the matter is not deemed to be misconduct or gross misconduct, the DCO must decide whether it reflects a need for improved practice, a performance concern, or requires no further action. When deciding whether to refer a practice requiring improvement, the officer's line manager should be engaged in the process unless that would be prejudicial to the consultation. All relevant parties must be informed of the assessment outcome in writing at the earliest reasonable opportunity. This written notification must also outline the complainant's right to request a review of that decision by the Commission. If the DCO decides that the behaviour is not suitable for agreed resolution and the complaint, if proved, would be misconduct or gross misconduct, they will appoint a suitable investigator approved by the Commission. That investigator can be an experienced police officer or civilian, providing they are not involved with the individual concerned or the case. The DCO will then provide the person complained about with a written notice detailing the relevant facts, outlining the disciplinary procedures, and identifying available options for obtaining legal advice. Where the conduct, if proven, would constitute misconduct or gross misconduct, a misconduct investigation must follow. Accountability and transparency are the cornerstones of public trust in our police force. That is why we have set clear expectations for the timely handling of disciplinary investigations. Officers have 10 working days to submit statements once an investigation begins. If an investigation is not concluded within the prescribed period, which is initially 12 months, and every 6 months thereafter, the DCO must report to the Commission outlining the progress made, the reasons for delay, and the steps being taken to bring the matter to a conclusion. When a misconduct investigation report is received, the DCO must promptly decide whether a police officer has a case to answer and refer it for the appropriate disciplinary process. No action can proceed until the Commission submits its statement of approval, and all relevant parties must be notified of the findings and next steps. If no case is found, the matter may be closed or redirected to performance review, except where the officer is no longer working. Let me now turn to how we address that misconduct within the service. It is important to note that the Commission must supervise misconduct investigations and any death or serious injury matters. The Commission must also be notified about a number of criminal conduct matters which are outlined later in Regulation 58. Cases of misconduct will be referred to a disciplinary meeting chaired by a Chief Inspector or another suitably qualified individual appointed by the DCO. Outcomes at this stage may include either a written warning or a final written warning. However, where an individual has already received a final warning or been demoted within the previous 18 months, the matter must be escalated to a disciplinary hearing. In each case of gross misconduct, a formal disciplinary hearing must take place. These hearings are overseen by a panel of 3, appointed by the Deputy Chief Officer to ensure fairness and independence. The panel has a range of sanctions at its disposal, from demotion in rank to dismissal with or without notice, which is a compulsory termination of service, or a requirement to resign, which allows an officer to step down voluntarily, though under clear direction. In some circumstances where appropriate, the outcome may instead be a written or final written warning. This structured approach ensures that disciplinary matters are handled fairly, proportionate, and with the seriousness they deserve. The Commission plays a vital oversight role in our system. It may provide written input or attend hearings when invited, and the appointed investigator or a qualified representative must be available to answer any potential questions commissioners have. Before any case is closed, the Commission must be satisfied with both the process and the outcome. Let me now briefly address the appeals process and the use of reflective practice review. Appeals must be submitted to the Commission within 28 days, with extensions permitted. An appeal panel comprising a Royal Court judge and 2 jurats would be convened, coordinated by the Judicial Greffe. I spoke earlier about reflective practice. This can be used for developmental purposes to learn from mistakes where under the old law disciplinary action would have taken place. A reviewer, who would typically be a line manager or senior officer, will engage the officer in a structured process to identify lessons and improvements. A report is then shared with the DCO and monitored over 12 months. If the officer does not engage, the matter will be referred to the DCO for review. These measures ensure fairness, accountability, and continuous professional development within the service. This piece of legislation is not just about process, it's about the trust, it's about ensuring that our police service remains accountable, transparent, and worthy of confidence placed in it by the people of Jersey. These regulations present a significant step forward in our commitment to transparency and accountability and fairness in policing across our jurisdiction. I propose the principles, sir.
Thank you, Minister. Are the principles seconded? Thank you. Does anyone wish to speak on the principles? If no one wants to speak on the yes, Deputy Scott.
In the course of a review I was conducting into the implementation of the States Assembly to bring forward a public services ombudsman, I did have the opportunity to speak with the chair of the Jersey Police Complaints Commission about the way in which complaints are conducted, and I was very impressed by the work that the volunteers from the Commission have done, and also the amount of thought that has gone into what needed to be improved in the complaints handling process. I therefore, and indeed a lot of thought given in terms of the standards that are to be applied in handling complaints, the importance of having an appropriate qualified investigator, giving of reasons and maintaining anonymity of the identity of the complainant, and all for good reasons. And I'm very pleased to see that progress has been made in this area and give my full support to these regulations.
Thank you, Deputy. Does anyone else wish to speak on the principles? Deputy Balash.
Sir, the Minister has given a very comprehensive explanation of these regulations, and I understand entirely the need for accountability of police officers, ensuring that processes are proper and comprehensive, and so on. I do have some reservations, I suppose, about the copying and pasting of United Kingdom regulations and incorporating them into our law in Jersey for one reason, and that is that we are a very small place. The States of Jersey Police consists of not more than 200 officers, whereas the police forces in the United Kingdom have thousands of officers. And when one looks at the detail of the processes which we are importing into Jersey, I do have some concerns as to whether we can cope with it. We don't want police officers to spend their entire time investigating each other on complaints which may or may not be serious. They should be engaged in investigating what I might call proper crime. However, I mean, I am not going to oppose these regulations because I do understand, as the Minister has explained, that there are advantages in having regulations which are consonant with the regulations which apply to other police forces in the British Isles. But I do express, as I say, some reservations about the importation of these extremely comprehensive rules.
Thank you, Deputy. Does anyone else wish to speak on the principles? Commencement, St Lawrence.
Yes, thank you, sir. It's just occurred to me that this does seem to be far more involved than the previous law and regulations, and I do wonder whether consideration has been given to the impact on the officers involved, because I know that when officers are under investigation and it does take a certain amount of time, quite a considerable time, then it can have a detrimental impact on their mental health and well-being. And I do wonder what consideration has been given to the, I think, far more detailed process, which we will probably be agreeing today. Thank you, sir.
Thank you, Commencement. Does anyone want to speak on the principles? Minister.
Thank you, sir, and I would agree 110% with Deputy Scott's view in relation to the role of what is going to hopefully be the Police Commission. I fully hear what both the Constable of St Lawrence and Deputy Bolosh say. However, having spent a significant time in the rank of Inspector and Chief Inspector, and having done the role of the Inspector in the Complaints and Discipline Department for 12 months myself, even though this looks more complex, I would say that the introduction of the element of the performance review, I think, is a good one, because we had an informal resolution before, which basically was a case of the complainant was happy with an informal resolution. The officer was told this is, they were unhappy with this, you had no recourse, and there was no development process put in place. So from my perspective, the element of having somebody monitored for the period of 12 to 18 months, I think is a good thing. I think the division of what was a number of different offences, lots of different pieces to the legislation. I think now that we've got 3 distinct areas, I think people will be dealt with at a lower level in relation to their performance, which would have ended up potentially in the realms of a full hearing. So I think, and I do understand that people don't like us bringing in law from the UK. However, what people will see is that on a number of occasions, we utilise UK forces to investigate on our behalf. Particularly, that would occur in relation to serious injury or deaths. And so I think from that element, it is always benefit for some of the legislation to fit in side by side. As I said, having worked with the previous legislation, I'm quite confident that this is workable, sir.
Thank you. Is the appel called for?
Yes, please, sir.
Appel has been called for. Members are invited to return to their seats. I'll ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. And the principles have been adopted unanimously, 44 votes for. Deputy Catherine Curtis, does your panel wish to scrutinise this matter?
No, sir.
Thank you very much. Minister, do you wish to propose the regulations in second reading?
Yes, please, sir, and I'd like to propose them en bloc.
Thank you. Are the regulations seconded? Yes. Does any member speak on the regulations in second reading? Deputy Rob Ward.
Thank you, sir. And I just want to apologise to the Minister. I meant to ask this the other day, but I know she was rather busy yesterday after the hearing, sorting out the question that was there. It's just Regulation 5 on suspension. And just wearing a previous role as a representative and a caseworker for trade unions, whenever there's a suspension, it's a really difficult time. And I just wanted to confirm, in the suspension, so my screen, that's why I never use my screen to talk, sir. Part 8, it says if a police officer is suspended or designated person designation is suspended, they are not entitled to be paid an allowance. It does detail afterwards some specific examples when pay won't be there. And I just wanted to check whether the allowance is their regular pay or it's additional allowances that may go in terms of overtime hours or particular roles they may have, or allowances for whatever allowances exist in the police force. Because I know there is I always had a problem when people were suspended from their workplace without an outcome, without pay, unless there was a specific outcome in mind and there was a specific thing that had been proven in the workplace. So I just wanted to confirm what that was for that regulation, sir. Thank you.
Thank you, Deputy. Does anyone else wish to speak in second reading? Minister.
My apologies. Can I just ask what part would he say? Section 5.
Yes, whenever we do regulations, I always have trouble with this because we have the bold number, which I think is regulation 5. The heading is suspension.
It's regulation 5.
It is
Minister.
regulation
5, subparagraph 8 refers to the police officer who's suspended not being entitled to be paid an allowance while they are suspended. Yes, Minister. Do you want to respond to...
Sorry, sir, but yes, I can respond, but I didn't know if anybody else has wanted to speak.
No, we've closed the debate.
Sorry, sir. In relation to police officers, there will be a standard pay which all police officers receive. However, there will be elements of pay which police officers will receive for some of the additional things that they do. Off the top of my head, you would have... we don't have them anymore, but dog handlers would get a certain amount of allowance. There used to be allowances in relation to specialisms, as an example, an on-call allowance and all of those sorts of things. So those things would not be paid. It would be that they would be paid the normal basic salary, sir.
Just thank the Minister. I thought that would thank you.
Thank you, Minister. Thank you.
I call for the Pell, sir, please.
The Pell has been called for. Members are invited to return to their seats. And the greffier is asked to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. Yes, Deputy Moore, your vote, well, you can't vote because you're still on default. So the voting is, in fact, 43 votes for, no votes cont. So the matter has been adopted unanimously in second reading. Minister, do you propose the matter in...
So may I, at this point, then raise a defo on Deputy Moore?
Is members content to raise a defo? The defo is raised. Minister, do you propose the matter in third reading?
Yes, please, sir.
Is the matter seconded in third reading? Does anyone wish to speak on the regulations as adopted in second reading in third reading? Those in favour kindly show. The appeal has been called for. Members are invited to return to their seats, and I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. The regulations have been adopted unanimously in third reading, 44 votes for. The next item is the draft police complaints and conduct Honorary police regulations, lodged by the Minister for Justice and Home Affairs. The main respondent is the Chair of the Children, Education and Home Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Police Complaints and Conduct Honorary Police Jersey Regulations 2000. The states make these regulations under Articles 8.1a, 9.6, 19.2, 3 and 4, 2010 and 22 of the Police Complaints and Conduct Jersey Law 2022.
The Minister will propose the principles. Minister.
Apologies. Sir, in my previous speech, I outlined the background and rationale underpinning the police complaints legislation as it applies to the States of Jersey Police. Rather than revisit that in full, I will focus on the key distinctions within the Honorary Police Complaints legislation, highlighting only where it differs from the proposed framework for the States of Jersey Police. You will recall that the States of Jersey Police, once the police officer has received the complaint, it is largely the DCO who leads the complaints process. For the Honorary Police, these roles will primarily be allocated to the AG and the Constable, respectively. For example, in relation to complaints against unknown officers or where an officer needs to be suspended, it is the AG who would deal with it. If a criminal offence is suspected, the AG must refer the case to the SG. Written complaints about honorary police officers go to the relevant constable, who records the complaint, secures the evidence and informs the AG and the Jersey Police Complaints Commission. In line with State's police procedures, with the Commission's agreement, the AG may decide not to pursue a complaint or to adjust how it is handled where it is clearly without merit. The agreed resolution process and the reflective practice review is led by a constable appointed by the AG, and the outcome is formally recorded and submitted. If that constable declares an interest in the complaint or it involves the chef de police, the AG will allocate it to a different constable. If the conduct is assessed as misconduct or gross misconduct, the AG will request the DCO to appoint an investigator approved by the Commission. This may be a senior police officer who is at least the rank of inspector or a suitably qualified civilian, provided they have no involvement in the case or within the individual concerned. When a misconduct investigation report is received, the AG must promptly decide whether a police officer has a case to answer and refer it to the appropriate disciplinary process. The disciplinary process itself is slightly different for the honorary police, as there is no provision for misconduct hearings, as you would have for a State's police officer, only a misconduct meeting. Cases of similar misconduct will be referred to as a disciplinary meeting, chaired by either the AG or someone suitably qualified and appointed by them. Possible outcomes include a written warning, a final written warning, or if a final written warning is already in place, dismissal with or without notice, or a requirement to resign. However, if the behaviour amounts to gross misconduct, these outcomes may be applied even without a prior warning. And where gross misconduct occurs and a final warning is already in place, either dismissal or resignation will be required. This approach ensures that disciplinary action is fair, proportionate and consistent with the seriousness of the conduct. As with the States of Jersey Police, the Commission plays a vital oversight role in the whole process. The appeals process for honorary officers is the same as that process for the State's Police. The reflective practice review led would typically be the constable or chef de police who will engage the officer in a structured process to identify lessons and improvements. A report is then shared with the Attorney General and monitored over 12 months. If the officer does not engage, the matter will be referred to the AG for review. As with the State's police complaints process, this legislation is not merely a matter of procedure, it is a matter of trust. It is about safeguarding the principle that our police service must remain accountable, transparent and deserving of the confidence entrusted in it by the people of Jersey. These regulations mark an important step forward in strengthening our commitment to openness, accountability and fairness in policing throughout our jurisdiction. I propose the principles.
Thank you, Minister. Are the principles seconded? Yes, sir. Deputy Morell.
Sir, I didn't want to make a speech. It's just a request. Just when, for members of the public who are listening, when members are speaking, I was wondering if they could at least once, when using acronyms, refer to what the acronym means at the beginning of the speech, rather than just going straight in. There's lots of AGs and SGs, but I don't think there was a single explanation for the public of what the AG or SG is, so it's just a recommendation. Thank you.
Thank you. Does anyone else wish to speak? Deputy Scott.
So just a point of procedure. Has the amendment been accepted, or is it?
We come to that on the regulations in second reading.
Okay, thank you.
Thank you. Yes, Conor Brillard.
Thank you, sir. I stand to support the proposition. I'm sure the amendment will be discussed when we get to it. But I think in principle, one of the points which we need to ensure takes place that any process as a result of the complaint is swift and to the point. We have experienced long drawn out complaint processes, which is really unfair on the those involved, both parties in fact. And so I would like the Minister to confirm that will be the case. Likewise, sir, I think we have to take care in not being over draconian in our approach, because we'll put people off joining the Honorary Police. And one of the, they're all volunteers, and the way you deal with volunteers, of course, is different from dealing with paid employees, such as the States of Jersey Police. And I'm sure that'll be reflected in the way the Commission approaches complaints, as it is by us constables, should we say, when we are faced with a complaint. Thank you, sir.
Thank you, Conor St Lawrence.
Thank you, sir. Well, the chairman of the committee has beaten me to it, actually, but I rise just to endorse the words that he has said about the potential for delay. That's not what we want to see with these new regulations. I'm sure most of us who have dealt with complaints against members of our Honorary Police in the past know of long delays and the detrimental impact that has had on, notwithstanding that they are elected to the role, they are volunteers, and we just don't want to see that. And that really was the nub of the question that I asked the Minister in the previous debate, because I'm aware of the impact that delays have on certainly the Honorary Police members, and I was concerned about the impact potentially on States of Jersey police officers. So I do hope that the Minister will be able to reassure us that these changes, particularly involving the newly named Commission, will not have a detrimental impact on the well-being of our Honorary Police officers. Thank you, sir.
Dr. Scott.
Thank you, sir. Following on from the Constable St Lawrence's concerns, I agree that any complaint can have a detrimental impact on the person who's the subject of the complaint. I note that the committee has itself proposed an amendment to the Regulation 55, which refers to the police friend. And this is, I think, a very important thing to consider about people who are subject to complaints, particularly if they are being properly investigated. It may well be protracted, and it can be a very lonely place. So the need to give support to people in these circumstances without judging them is really essential, because it's about the welfare of those people as much as ensuring accountability. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on the principles? Minister.
Thank you, sir. From my perspective, I genuinely believe that these new regulations will actually be better than what we have previously. As I've already said, I think previously, if it wasn't an informal resolution, it was a full investigation. So I think now, with the difference between the three different sections, I think that will make a difference. In relation to the element of friends, I think this is exceptionally important that both, whether it's an honorary police officer or a police officer, that they have somebody that they can make sure that they keep contact with them, ensure their welfare moving forward. So I think these elements are exceptionally important, sir.
Thank you. Do you ask for the appel?
Apologies, yes, please, sir.
The appel has been asked for. Members are invited to return to their seats, and I ask the greffier to open the voting. All members have had the chance of casting their votes. I ask the greffier to close the voting. The principles have been adopted. 44 4 votes for, no votes contra, and 1 abstention. Deputy Catherine Curtis, do you wish to scrutinise this matter through your panel? Yes, we've seen your report. Thank you very much. Minister, there is an amendment lodged by the Comité des Connétables. Do you accept the amendment?
Yes, sir.
Members content to take the regulations as amended? Yes, sir. Thank you. Minister, how do you wish to propose the regulations in second reading?
En bloc, please, sir.
Are the regulations seconded?
Yes, sir.
Does anyone wish to speak on the regulations in second reading? All those in favour of adopting the regulations kindly show.
Appel, please.
Appel's been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all those members have the chance to cast their votes, I ask the greffier to close the voting. I announce that the regulations have been adopted in second reading. 45 votes for, no votes contra, and 1 abstention.
Deputy Balash.
Minister, do you propose the matter in third reading?
Yes, please, sir.
Are the regulations seconded in third reading? Thank you. Does any member wish to speak on the regulations as adopted in second reading in third reading? That concludes the debate in third reading. Is the appel called for?
Yes, please, sir.
The appel has been called for. Members are invited to return to their seats, and the greffier is asked to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. And I can announce that the regulations have been adopted in third reading. 45 votes for, no votes contra, and 1 abstention. The next item is the Draft Police Complaints and Conduct Commencement Act, lodged by the Minister for Justice and Home Affairs. The main respondent is the Chair of the Children, Education and Home Affairs Scrutiny Panel. I'll ask the greffier to read the citation.
The Draft Police Complaints and Conduct Jersey Commencement Act 2000. States make this act under Article 24 of the Police Complaints and Conduct Jersey Law 2022.
Minister.
Thank you, sir. Following the previous 3 pieces of legislation, today we arrive at the final piece of the jigsaw, the Draft Police Complaints and Conduct Jersey Commencement Act. This Act will formally bring into effect the Police Complaints and Conduct Jersey 2022 on the 5th of December 2025. Together, these measures mark a significant milestone. They ensure that our police complaint system is not only fit for purpose, but that it is fair, transparent, and above all, trusted by the public whom we serve. This is about strengthening accountability, reinforcing confidence, and upholding the highest standards in policing for the benefit of our community. I therefore commend this Act to the Assembly.
Thank you, Minister. Is the Act seconded? Does anyone wish to speak on the Act? All those in favour of adopting the Act kindly show.
Appel, please, sir.
The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. The Act has been adopted unanimously, 44 votes for. The next item of business is the draft sea fisheries minimum size limits. Amendment number 2 lodged by the Minister for the Environment. The main respondent is the Chair of the Environment, Housing and Infrastructure Scrutiny Panel. I'll now ask the greffier to read the citation.
Draft Sea Fisheries Minimum Size Limits, Jersey Amendment Number 2 Regulations 2000. The states make these regulations under Articles 6 and 29 of the Sea Fisheries Jersey Law 1994.
I ask the Minister to propose the principles. Minister.
Thank you, sir. Sir, our scallop fishery is in a strong position. Landings and landings per unit effort have increased in recent years, reflecting a healthy stock on our seabed. However, we must ensure that this success is not short-lived. The decisions we make today will help determine whether future generations can enjoy the same benefits. That's why I'm proposing a small but important step forward, increasing the minimum size of king scallops from 102 millimetres to 105 millimetres. This proposal initially came from the fishing industry itself, who are looking to safeguard their fishery. This adjustment may seem small, just 3 millimetres, but its impact is significant. By allowing scallops a few extra months to grow, we increase their reproductive potential and strengthen the resilience of our stock. Our data shows that this change will enable an additional 19% of 2-year-old scallops to breed, contributing to the next generation, and safeguarding the long-term health of the fishery. Yes, this measure will mean 7% of extra catch needs to be returned to the sea, but only for a short period, approximately 4 months, before the growth compensates for the change. In return, we see a stronger fishery with a higher quality product for the market, which in turn is worth more to the fishers. This proposal is not the end of the conversation. I will also explore a further increase in consultation with Jersey and French industry partners, including other management measures. Larger scallops produce more and better quality eggs, and harmonising our standards with neighbouring regions such as Normandy and Brittany will strengthen our shared commitment to sustainability. In 2026, I will be bringing forward the Sea Fisheries Trawling, Netting, Dredging regulations to the Assembly, which is reviewing other technical measures such as the ring size used for catching scallops with dredgers. Officers in Marine Resources are currently working with Bangor University on a scallop stock assessment to ensure the stock remains sustainably harvested for the future, with publications due in 2026. But today, I ask for your support in taking this first step. By increasing the minimum size limit, we are investing in the future of our fishery and our environment. I propose the principles, sir.
Thank you, Minister. Are the principles seconded?
Yes, sir.
Does anyone wish to speak on the principles? Deputy Renner.
Thank you, sir. So this proposition, I think, is a good measure, and of course I fully support it. But it is not enough. The Minister alluded to that, but I would like to go a bit further. It's not enough if we want to have a sustainable scallop fishery, and indeed a sustainable wider fishing industry. And I think it is important to make this point because there is a risk that we will be seduced into thinking that by passing this proposition, it is a case of job done. It is not. So I want to talk about the bigger picture because I think the situation is actually quite urgent. But I do want to start with some optimism. I do think there is a big prize for Jersey that is within our grasp, and this proposition could be a first step on the way. We are ideally placed, if we wish, to become a beacon of sustainable fishing. I think we could actually be great at this. And in my view, how we approach fishing could actually fit into a bigger vision for the island. But I don't think we're remotely in that place at the moment. Currently, we have, for the most part, a fishing industry that relies on high volumes and, unfortunately, a low price. We have historically supplied relatively low-cost lobsters to France, and recently we've apparently been selling scallops in bulk to the UK, again for a relatively low price. in my view, the transition we need to make is to a lower volume, high value industry. And the basis of that high value industry will be that it is sustainable, and not just that we say it is sustainable, but that it is verifiably sustainable. And for me, that fits into a wider vision about Jersey's future. In broad terms, I guess you could say we should not be aiming for a mass market, if we ever did. We're too small for that, and it plays against our unique island identity. The kind of words I'd use to describe where we should position ourselves as an island include words like high quality, boutique, unique, specialist, curated, well-regulated, sustainable, high value. Whether that's in fishing, farming, finance, tourism, our identity depends on identifying opportunities that fit within those kind of parameters and seizing them. Back to scallops. The state of the scallop fishery. As the Minister says, on the surface, scallop fishing is booming. Last year, the catch by the Jersey fleet was over 1,000 tonnes. But is it sustainable? Between 2007 and 2021, the Jersey catch was around 250 tonnes a year. In the space of just a few years, it has rocketed, a fourfold increase. The French fleet scooped up an additional 800 tonnes last year, which is also an increase on previous years. This dramatic increase in scallop catch might suggest that all is well, but it is not sustainable. It follows the same sad path that the overexploitation of every fish stock follows. In the past, we had a significant conger fishery, a flatfish industry, long gone. And if you dive into the annual fisheries report from the Marine Resources Department, you can see the same story playing out again and again. Whelks, a rise to a peak catch of 800 tonnes in 2018, then collapse. It's virtually zero today. Brown crab, as recently as 2013, the annual catch was 500 tonnes. Now, virtually zero. Lobster peaked in 2011 at 275 tonnes. Now, virtually zero. There are some species-specific factors contributing a bit to those declines, but overall we have a fishery that has a built-in boom and bust. We find a profitable stock, we overfish it, and then it collapses. It's no good blaming changes in sea temperature or the return of octopus. They may play a small role at the margins, but if these were the causes of the collapse of stocks, then the pattern of decline would be very different. It is overfishing that is the problem. And if we want any further evidence, can I recommend to members a talk that is taking place today, lunchtime today at the Société, by the former head of Marine Resources. By a remarkable coincidence, he's talking about the history of the Jersey fishing industry, and in particular, the collapse of the oyster fishery in the 19th century. The talk is relevant because Jersey has an unwelcome place in history. The collapse of the Jersey oyster fishery was, in fact, the very first recorded example of the complete collapse of a commercial fishery. It was the result of a frenzy of overfishing, led to conflicts with France and conflicts within Jersey too. For example, our forebears in the States attempted to stop oyster fishing in an area known as the Grouville Bed to try and protect oyster breeding grounds. In fact, the States banned fishing in this area. But the fishing industry was not happy, and in the end they ignored the ban and went fishing anyway. And of course, the eventual result was the total collapse of the fishery. Maybe members think it's too distant in time to be relevant, but there have been many similar collapses since. North Sea herring in the early 1970s, the Grand Banks cod in the early 90s. They all follow the same pattern. A rapid ramping up of fishing, chasing quick profits, followed by collapse. Right now with scallops, we're in the boom. It's virtually the only fish stock left in the island's waters that is commercially viable at the moment. But a bust will surely follow unless we take additional measures. And then what will we be left with? I'm not getting at fishers here. Members will be familiar with the concept of the tragedy of the commons. It is entirely rational for any individual fisher to seek to maximise their catch. The trouble is that the sum total of those individual actions are against the long-term interests of the collective. That is why we need to regulate the catch. And the biggest, most important measure we need to take is to reduce effort. We need to catch fewer fish, fewer scallops, not more. And in this regard, I am heartened that in an answer to a recent written question, and the Minister has just repeated it now, he confirmed that he is working on setting what is known as a total allowable catch, a TAC, for scallops, and then I hope for other species. The total allowable catch is defined by independent scientific research, and it is based on identifying the total tonnage that can be taken each year for the fishery to remain sustainable, what's known as the maximum sustainable yield. That's scientifically determined, and it can be used to set the total allowable catch and then quotas allocated on that basis. I cannot emphasize enough the importance of setting those catch limits. I just hope we get the total allowable catch in place before it is too late. There is one other positive step. Last year, we voted to create marine protected areas. And although the MPAs are not as extensive as I hoped, they are nevertheless important, a vital positive step. And there is still the possibility that the areas that the Minister initially declined to designate as MPAs, but designated for further research, will be added to the MPA network once the research is in. And the more of that sensitive merle habitat we can protect, the better for the long-term future of the fishery, because these areas are nurseries for scallops and indeed for other species. I know that there is pressure from some parts of the fleet, and indeed the French fleet, to delay the introduction of the MPAs, which is scheduled for September next year. All I can say is that I urge the Minister to stick to his guns, resist the pressure, and introduce the MPAs on schedule, and I would respectfully ask him to address that point in his summing up. So I started by saying that we have the potential to create a high-value sustainable fishery. And going forward, there is a way to get there. We will need to reduce the catch and support the fleet through that transition. We need the industry to coalesce in the way that farmers did with the Jersey Dairy to form a producer organisation. We will probably need a fishery hub to process and store catch. And we need to work hard to develop a local market so we are not dependent on export markets which constitute a single point of failure. As an example, when it comes to hand-dive scallops, there is a real opportunity to establish a strong local market in hand-dive scallops which are entirely sustainable, and which is why I again lament the failure last year to protect one area of the fishery for the scallop divers. So if I may sum up, the increase in size limits is a good start, but on its own, it will not save the fishery. Without catch limits, the fleet can simply increase its effort, compensating for any shortfall in catch that happens because of the size limits by simply fishing harder for longer. It is what always happens. So the outline of what we need is clear. First, increase size limits, because it is important and it is a good step. Second, work to establish the maximum sustainable yield, which is then used to set an annual total allowable catch, because this is the absolutely vital measure to keep fishing within sustainable limits. Third, expand the marine protected areas to include all the areas, the most sensitive areas of merle, because they are so vital as nursery grounds for scallops and other fish. And then finally, get behind a sustainable fishing industry with relevant investment and marketing. So yes, let us vote wholeheartedly for these regulations, but please let us not stop there. We can have a sustainable scallop fishery, And wouldn't it be nice if, as well as a footnote in history in relation to the collapse of the oyster fishery, we had a more welcome place in history as the home of a really modern, integrated, sustainable scallop fishery? Because, after all, they are jolly tasty.
Thank you, Deputy. Does anyone else to speak on the principles? Deputy Taddeo.
Thank you, sir. I won't speak in such a technical or eloquent way as my St Brillard deputy colleague, sir, but I do very much share the same principle, and I was motivated even before the debate to want to speak on this. I think it is the kind of debate where I think we don't often get a chance to talk about scallops and about dredging more in particular. And I think this is a time where those of us in the Assembly who feel strongly and are reflecting, I think, a wider concern in the general public about the sustainability of our fisheries, do put it on record to encourage the Minister for Environment, because I think he does need encouragement. I think he knows, he also wants to do exactly what the Deputy Reniff has mentioned and what I may mention, but he is, of course, trying to balance economic needs along with environmental ones. And I start this by being reminded, as we were reminded recently, as my scrutiny panel was reminded, that when Deputy Morell took over at Economy as Minister, he was at pains to make sure it was called Sustainable Economic Development. And I think this does then bring into question, of course, and this is a step in the right direction, absolutely, sir, increasing the shell sizes by a few millimetres is a positive step. But if we want to be really sustainable when it comes to both the economics and the stocks and the environmentalism and longevity of our scallop fishing industry in Jersey, I think there is ultimately one thing that we need to do, which is quite radical, but we need to ban dredging for scallops in Jersey waters, because there is an alternative. And if you go up to the likes of Bonwy Bay, not just in the summer, but at the few occasions during the year when my wife and I indulge in fresh scallops, we get them straight off the boat. And you don't know exactly when they're coming in, but there's a sign there and it says hand dive scallops, sir. And you know roughly when they're going to come in, and they don't get any fresher than that. But also, more importantly, they're caught in a very sustainable way. You've got these groups, they are a group of men who go out, dive for scallops, and they don't get any fresher than that. And the question I had for the Minister is that, OK, there are going to be these new limits which are higher, but when one dredges, of course, there are all sorts of things that can happen. So even when the new dredging changes are coming in to change the diameters of the dredging equipment, there are things that happen, like stones can get caught in the dredging equipment when they're taking up scallops, which mean that smaller scallops will get caught up in the dredging equipment. Also, the stones can lead to more damage occurring in the scallops themselves. The advantage of hand diving is, of course, you can see. I suspect they don't go around measuring them, but I suspect a hand-dived, a skilled and experienced diver for scallops will know instinctively, roughly, which are the ones that are big enough and which are the ones that are small enough. And they'll probably err to the side of caution. You know, there's no point in bringing up a bag full of scallops if you have to get rid of 10, 20% of them. It's just not efficient. So you may well only take the ones that are certainly going to be above the limits. My question to the Minister is, when scallops are dredged in particular, it's fair enough to say that the smaller ones will be returned to the sea, but where do they get returned to the sea? Do they get returned at the point at which they're fished and put back into the freshly dredged seabed, or do they get returned nearer the port? So are they getting dropped over the side, at which point they're not going to be in their normal breeding grounds, in their normal foraging habitats? There is also some interesting papers that are out there on the internet, and one that I've been looking at is from an organisation called Project UK, which did a review of alternative measures that minimise the mortality of unwanted catch and reduce habitat impact in the UK king scallop fisheries. And really, it seems that they collated a whole load of studies that were done over a period of years in the last 20 years. And there seem to be two factors on whether and how scallops survive when they get returned to the sea. And the two main factors they looked at were, one, stress on scallops. It sounds like a strange thing to say, doesn't it? Stress on scallops. They might need to have a couple of days off work so that they can get back to being a scallop. That's, of course, not what it means. Scientifically, the reason they talk about stress is because it's partly about how long it takes them to reburrow into the sand or the seabed. But the other more important factor, which they did find was significant, was the level of damage that had occurred to scallop shells. So this idea that you just have a higher limit in terms of the size and therefore you can return them to the sea and the scallops will be all right and they'll survive isn't necessarily the case. What they found is that the majority of damage that occurred to scallops was during the initial impact with the dredge teeth. And they found that batches of scallops which were undamaged, they tested batches of scallops which were undamaged, lightly damaged and badly damaged. And what they found is that the density of scavengers at the stressed but undamaged scallops was equivalent to the density of during the unbaited period. So what that's saying is that when healthy scallops are returned to the sea, they're much less likely to get attacked by scavengers, but that the stress, and that stress wasn't really a factor in that, but the damaged scallops was where there was a significant increase in the density of scavengers. So lots of scavengers will be coming around, and they found over the period of 96 hours following their return that the badly damaged scallops were all eaten within just 24 hours for each of the two replicate periods, and that the scallops that were lightly damaged survived longer, but the survival rates differed among replicates. So what this says to me is that we've got an industry in Jersey which is for scallops. My understanding, and perhaps this is something that the Minister can confirm in summing up, is that most of the dredging that happens for scallops, that takes place for scallops in Jersey waters, doesn't happen by Jersey fishers, it happens by European, i.e. French fishers, and that we really need to think about the sustainability of our markets. And I think Deputy Reniff is right. I think Jersey needs to look towards a more premium product. It says, yes, we have a sustainable fishing industry, at least where it comes to scallops. They are a premium product and they will be sold locally and hopefully exported, whether to the UK or to France. And okay, there may be a premium to pay for that, but you know that there's a label, a brand that comes with that, which is that these scallops are not only caught with love and sustainability, but they're actually much more sustainable. I do question, when will humans ever learn? Because we seem to have a lot of cognitive dissonance. It's very possible, I think, for islanders, states members to, on the one hand, promote the great work that Durrell do, for example, and people talk about conservation, sustainability, protecting the environment, looking after the planet, looking after animals, whilst at the same time not learning the lessons from history. One very good book that I read recently, but it's not that recent, it's from 1997, simply called Cod, Sir, C-O-D, as in the fish, written by Mark Kolansky. And he goes through, of course, the history of cod and how important it was to the world, and that when a particular industry, fishing industry, is booming, that's probably the time that you need to be most worried, because there's complete complacency. You think there's a stock that's almost limitless, and certainly when it came to cod, the ethos amongst the global community that this was an endless resource, and that there's no way that a small impact like fishing could ever stop Mother Nature from replenishing the cod stocks. And of course, how wrong that they were, and we were on that. And it's exactly the same when it comes to scallops. Deputy Reniff is absolutely right that the oyster fisheries in the channel between Jersey and between the French, we managed to wipe out completely the natural oyster in Jersey, to the point that only later on the slightly different cultivated oyster did make a return to our shores, but it was not an easy process, and that was certainly not inevitable, sir. So I, for one, will of course be supporting this, but I would like the Minister to give real consideration to whether or not a more radical approach can be brought forward. There will no doubt be big political consequences that need to be handled if Jersey were to be as bold in the future as to bring in a complete ban on scallop dredging, sir, in our waters. But I think we could do that on the justification that it applies to everybody equally. So it applies to Jersey, Guernsey, French fishers equally, and that ultimately the prize will be one that is worth fighting for.
Thank you, Deputy. Commentator St Lawrence.
Thank you, sir. I need to be quicker off the mark in trying to attract your attention to speak, because this is the second time today that I have been beaten by another member to actually saying what I want to say. So Deputy Tadjer has effectively stolen my thunder, I think, sir, and so my speech is going to be much shorter as a result of that. When the Minister spoke, I felt there was a tension in his words because he referred to dredging and he referred to sustainability. And that always makes me feel uncomfortable. I don't want to repeat what Deputy Tadjer has said, but I think I just need to put a question to the Minister regarding this. I think the regulations that we have on dredging are probably quite tight compared to other jurisdictions. However, I would like to ask the Minister whether he is considering tightening, strengthening those regulations on dredging to provide sustainability not only for the scallop stock but for other marine life that is caught when dredging. And if not, sir, why is he not giving consideration to that? Thank you.
Thank you, Commentator. Deputy Ward.
Thank you, sir. And I really appreciate this debate opening up to just not about the size of a scallop, but actually this wider concept about what our fishing industry should look like. And the word that just keeps banging into my head all the time is vision. Where is the vision for the future of this industry? And actually, I was really struck when we were doing this under scrutiny with the marine areas, protected areas, and struck by the people who sat in front of us at scrutiny. And they were a combination of people. They were the dredgers, they were the well, there actually weren't very many hand diving people. It was just much more the dredgers who had the biggest influence. And what I came away with was actually it's not an industry as a whole, it's a really divided industry. So no two people seem to have the same view of what's going on. And subsequently, funnily enough, after that scrutiny hearing, I was in my cafe and there was this guy in these big boots and I said, oh, you look like you're one in the fishing industry. I said, yes, I'm a hand diver, I go out there. I said, well, why didn't you appear in front of the scrutiny committee? He said, I don't have time. My day is spent out there collecting, getting the fish, and not actually being able to spend time talking to scrutiny. And so I've got to make a living. I've got to pay my mortgage. I've got to, put food on the table. And sometimes this is some of the problem. We don't actually connect very well with the people at ground level who are actually in the day-to-day who could actually really inform this debate. So I think there's a lot of theorizing in here, and I appreciate Deputy Renner's commentary around, the environmental consequences and obviously the collapse and all of these things. But actually, this is a big conversation about what is the shape or the future shape of our fishing industry going to look like, and it is that exact tension between the economics and the environmental issues, which are very clear. So I just want to encourage whoever's in charge of the Environment Minister who's involved in this, is to somehow work out what it is. We talk about sustainable catches. What the heck is a sustainable catch? I have no idea. But I'm sure there are a few fishermen out there who do know, fisher people out there, who do know what a sustainable catch looks like. They also want a sustainable living. They want a sustainable future as well. The industry, as I understand it right now, is as small as it's ever been in terms of the number of boats out there. Actually, why is that? Why are we having all of these issues? So I absolutely agree with the idea of let's go with quality, let's lower the volume. But actually, we have an export industry. I'm sure there's an export industry there because it's that volume that actually gives you sustainability. So there is your exact tension going ahead between the economics and the environmental issues. So I would just encourage I don't know, just a rethink. This is something I can see it on Regen with agriculture, which is really, really good news, and people are kind of getting it, that what Jersey is, it's a small scale environment. But we need that bigger conversation, that wider conversation. I absolutely agree with Deputy Renner in saying this isn't far enough. It's a step in the right direction. Absolutely. But actually the real vision is about talking to everybody in that industry and saying, what is the shape of this industry going to look like? How do we make it sustainable for everybody? And how do we make sure we're talking to everybody? Those are all things. I think too many times in this island, and I talk to so many people, is we are at a distance between the people on the ground who actually know, what I call the experts in the room, and finding their voice and getting that voice, that conduit, through into this assembly and making good informed decisions. So I just want to encourage that wider debate, Minister, but I obviously will be supporting this proposition. Thank you.
Thank you, Deputy. Parental.
Thank you. I just rise to speak in support of the proposition and just emphasise the point that the Department are in regular communication with fishermen on the sea, not on the ground. And I would add, sir, that most fishermen are fully aware of the sustainability issue. It's in their interest to do that. And I would almost say that the less government interference, the better, very often is the case. Referring back to mentions of the oyster fishery in the late 19th century, actually that was cleaned out by oyster boats from the east coast of England coming down and swiping our stocks, and I'm sure we won't be letting that happen again. Management of fisheries is a different thing these days. So, sir, I'm very supportive of the move to, which is supported by the fishermen, in keeping the size up to ensure preservation of the stocks and trying to ensure continual catches for future fishermen as time goes on, because that is of concern to the industry. Thank you, sir.
Thank you, Conor. Deputy Scott.
Thank you, sir. Yes, just following up from this whole lesson from history that we learnt, I did worry a bit about whether there could be some fishermen who actually are involved in the scallop industry who might find that discussion patronising, because it's a bit like saying that we're going to go back to employing children in certain ways. But, you know, the whole thinking, modern thinking is different, and I believe that the people involved in this industry care just as much about sustainability, and indeed it very much is their interest to have sustainability as most of us. And when people say this is a step in the right direction but it's not far enough, I would invite them to consider whether sometimes stepping in the right direction is what you need to do. You don't want to go too far either, because that can actually have severe consequences for the industry. You've got to do a certain amount of pacing and eventually perhaps some more in the way of leading. But the point is, I do believe there's been lots of discussion in this area about what is the right balance, and that we are where we are. It is in the right direction. And as with, I suspect, most people in the States Assembly, I will be supporting this proposition accordingly.
Thank you, Deputy. Conor St Martin.
Thank you, sir. And I will be supporting this proposition. I do think it's a step in the right direction, and maybe we just need to take quite a few more steps to get us to where we should be. I thought that I would like to really praise Deputy Renner for his very eloquent speech. I do think that we have to have more marine protected areas. We do have the MPAs at the moment, and in 2022 I met with Freddie from Blue Marine, I think it's Freddie Watson, who was talking about protecting the mole beds, which I really do believe we have to do. I would like to see a reduction of dredging. I'd like to see a complete ban on dredging, actually, and I think we could sustain it. I agree that we need to have a gold standard for fishing, and that if we have to charge slightly more, then so be it. I am supporting this. I would like to see us take quite a few more steps forward, but this is a step in the right direction. Thank you.
Thank you, Conrad. Does anyone else wish to speak on the principles? Deputy Morel.
Thank you, sir. And I thank everyone who's been speaking as well, because I work closely with Deputy Luce with regard to the fishing industry. Obviously, Deputy Luce focusing on the regulatory side and many of the international affairs elements, and I work with the industry, speaking to the industry about the business side of it. And there is no doubt in my Chamber of Commerce speech in September, I raised the fact that there is a crisis in the fishing industry, and that we do need to rethink in many different ways. But you have to put the bread on the table today. That's absolutely vital. And so I completely agree with the idea that one step is the right thing to do, because we do need to take it step by step by step, because otherwise you can be destroying livelihoods very, very quickly. But I do want to say, so the principal reason I rise is really to say that Deputy Luce and myself are commissioning work on the future of the fishing sector in Jersey. It is not easy. It was mentioned that there are many different views in that sector. It is true. It is not cohesive as an industry. There is no one industry view. And it is very complex. It is complex as well, not just because of, so even deciding scallop sizes, you know, the complexity comes in there. You will have noticed members will have noticed in Deputy Luce's speech, he talked about the French fishermen. You need to get buy-in from France on these things as well. It's not just Jersey. And listening to some members, I do worry that members think that we exist in isolation in terms of fishing. That was the mistake that was made by the fishermen who voted for Brexit. They forgot that they depend on markets, and those markets are not in Jersey. It is wonderful to think that Jersey will consume more fish, but today we don't. You cannot just change people's tastes overnight. That takes years and decades to change. It can be done, but it takes decades, because that's cultural, deeply difficult. It's also really difficult. Many of the issues that have been mentioned by members today are issues that are brought up in matters related to UK-EU agreements. We cannot even, as an island, operate on our own in that respect, because things we do with regard to our waters pop up in Brussels and pop up in London, and have an impact on what we can or cannot do. And so it is very easy to opine in isolation in our little ivory tower. But what I do know is that Deputy Luce is, like myself, entirely committed to creating a sustainable fishing sector. But it is a fishing sector which has enormous challenges right now. And size of scallops is the least of those challenges, because Deputy Reniff mentioned some of them, and they are related to the environment, they are related to geopolitics, they are related to just everyday life for the fisherman who needs to earn a living. In order to charge a higher price, again, this is something that has been said today, you cannot just charge a higher price by saying to markets in Europe, we want a higher price. That's not how it works, because there are lower prices all around you, so your fish won't get sold, it won't be bought. The only way you can charge a higher price is by adding value, and that means adding processing. And that is an area we will be looking into. But again, these are things that businesses can do themselves as well. Businesses in Jersey are processing fish products and selling them outside the island. But that is the only way you can demand a higher price. One person in the fishing industry recently said to me that they had been told that there was a buyer in Europe who would take as much spider crab as they could possibly take at market price. And this person was very pleased to hear this and was delighted and thought it's fantastic. But then, of course, jolted to reality when this person knows very, very well, far better than me. Obviously, the market price is set in St. Malo. The market price is not set in Jersey. And so things such as the cost of wages in Jersey are not taken into account in the setting of that market price. The higher cost base in Jersey is not taken into account in the setting of that market price. And therefore, it becomes nigh on impossible with the product on its own to charge a higher market price. The only way to do it is to add value, and that comes through processing. And so we are working, and I want members to understand that Deputy Luce and myself are working with the industry, but it is an industry that is feeling very fragile at the moment. And we do need, as Deputy Scott said, to take it step by step. It is too easy to opine and believe we can snap our fingers and change all these things. That is not something that can be done. There are too many different pressures and too many different variables. So we do need to negotiate these paths carefully. And that is what Deputy Luce and myself are trying to do. And this change to the regulations, increasing scallop sizes, is an important step forward. But it is one, and we will be taking many others afterwards. But we will be doing so at an appropriate rate that ensures that people's livelihoods are not destroyed at the same time as we move to a more sustainable and valuable, I hope, fishing sector. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on the principles? Minister.
Thank you, sir. And can I thank all those members who have spoken? It's encouraging to know that so many people take an interest in one of our most traditional of industries on the island. If I might just work backwards, sir, and start with Deputy Morell, and just reiterate to members how he and I work together on all these matters. He's right, the industry at the moment is in crisis. It is fragile. And as a farmer, I used to think every morning when I got up how happy I was to be working on the land and not having to go to sea. Working at sea and making a living at sea is a tough thing to do. And we need to bear that in mind as we make these changes, because I'll come to compromise in a minute. Can I just say, following Deputy Morell's speech, that he's absolutely right. All these regulations involve France, they involve the UK, they involve the European Union, and we, between us and the Minister of External Relations, Chief Minister, will tell you, we do extensive work in these areas. They are challenging, they are difficult, and we know only recently, every time one of us sets foot in Brussels, fishing is a subject which comes up. Whether we like it or not, it's really important to everybody concerned, and it's mentioned a lot. Can I thank the Constable of St Martin's, Deputy Scott and my Assistant Minister for their interest, and I will cover the points they make in my response to the first three speakers, because lots of things have been said, and I don't want to repeat myself. But Deputy Wall, yes, there is a vision, and I'll come to that right at the end if I may. But I want to emphasise, and I may as well do it now, in Marine Resources we are hugely fortunate to have a top team who are working on all the issues that I will talk about in the next 5 minutes or so. I can't say how grateful I am to have such knowledgeable and hard-working people in the department. Constable St Lawrence mentioned dredging versus sustainability, and she's right, there is a challenge there, but I will in a minute just address some of those, because it is possible to do the two, not everywhere, but it is possible to do the two. But the strengthening of regulations will come next year. This is a small step, and I will be doing more. Next year, as I mentioned, I will be coming back with some netting and trawling regulations and modifying those. Deputy Taddier mentioned balance and compromise, and politics is all about balance and compromise, but looking to the future, I share the vision of many here, Deputy Taddier especially. I see a vision of plenty fish in the sea, meaning that fishermen have to put in less effort to make a living and have a profitable business. It's not difficult to visualise how that might work, where you go out for just literally a few hours instead of spending all day trying to catch the same number of fish, because we've got a sustainable fishery which has plenty of product there. The difficulty we have is getting from this point today to that point in the future, and how we compensate fishermen, how we work with the stock, how we introduce those sustainable measures. So just getting to damage, yes, and Deputy Taddier mentioned it, yes, absolutely. Hand dive scallops come out of the sea in perfect condition. Dredge scallops, not quite so, though perfect at times. but we can work sustainably with dredging in the short term, medium term, and in the right ground, mobile sandy areas, it is possible to not damage the environment overly and to catch scallops without damaging overly, either by the stones that Deputy Tadier mentioned. The ring size is important, and for those who don't know, when the dredge is pulled along the seabed, instead of, as you might have a net for catching fish, when you come to catch fish, you have a series of metal rings in the bottom of your dredge, which allows stones, allows small scallops and other things to fall through. So hopefully you're left with large scallops. And varying the ring size is a very good way of making sure we don't do too much damage. Same as the fishermen burning a load of fuel, dredging stuff that they don't need to. As regards returning undersized scallops to the sea, obviously, as I've just described, some will fall through the dredge as they're being dredged, but those that find themselves on the deck of the boat would normally be returned within the first 10 minutes because the catch has to be sorted. So those scallops are going back to the area where they have been dredged. As for the Jersey-French amount ratio of scallops, as Deputy Wren said, in this last year or so, Jersey fishermen have taken more scallops out of our waters than the French fishermen, which is quite surprising given that we only have 10 boats and they have 37 boats, but they are limited to 1 tonne a day, and our boats are not limited to anything. And I'll come on to that in the future, if I may. So I'm going to come to Deputy Renner finally, but many of the points I will say in addressing his questions apply to everybody who's spoken here. He said, you know, is what we're doing today getting the job done? No, it's absolutely not. It's a tiny, small step in a number of steps that I want to take into the future, protect not just the scallop fishery, but the lobster fishery, what we have left of the crab fishery. And the MPAs are a big subject. They're very, very on the radar of the French fishermen at the moment and Jersey fishermen, and sometime next year there will be some announcements and some closures. We do enjoy a marine stewardship certification for our lobster fishery, but I have to say that our lobster catches are declining. Yep, we know that, but there's reason. A bit like the crab fishery has almost disappeared, and Deputy Renniff mentioned that, and he's absolutely right. What is happening is climate change is raising the temperature of the water. These crabs that were in Jersey waters are now prolific in parts of the North Sea. They have moved up the channel and they have disappeared. The other thing, of course, which is starting to hamper the lobster fishery is, of course, octopus. Again, because of rising sea temperatures, we're now seeing a lot of octopus. I'm sure members would have seen that reported in, especially the southwest of England. And fishermen are pulling lobster pots out of the sea where the shells of lobsters are there, empty, because they have been taken apart by octopus who've got into the lobster pots. That's unfortunate. And that's another challenge that we're trying to solve within the industry. I want to talk about products, niche markets, traceability and sustainability. And those people who have mentioned that, Deputy Morel, Deputy Tadier, Deputy Renniff, are absolutely right. We have a wonderful brand in the word Jersey, whether that's Jersey milk, whether it's Jersey new potatoes, whether it's Jersey seafood, whether it's Jersey oysters. Jersey sells, but it's important that we maintain top quality. We have, and I'll just come back to that right at the end, if I may. I want to talk just very briefly about the 1,000 tonnes that Deputy Renniff mentioned, and is that sustainable? I don't know, but I did mention that we're doing the work at the moment with Bangor University about the total catch which we could take out of the water, knowing that that would be a sustainable level. And by the time we get to this time next year, I very much hope that we would have come in with some limits on total allowable catch, TAC. Not very long ago, I capped the number of boats that can go dredging to 10. I'm not intending to extend that further. That's another small step. I take on board absolutely the talk about the native oyster industry. That was a very prolific industry. It supplied the whole of the south of England with native oysters, and yes, it was completely overfished and annihilated to the point where there's very, very few left. I've spoken about lobsters, I've spoken about crab, but I just want to return to two issues. And the first one is one that Deputy Morell mentioned when he spoke about he and I working together, and we have taken steps in very recent weeks to start putting together some immediate work that we want to do about the future of the fishing industry and how we can try to show some hope, show some new initiatives, show how we can develop new markets. And I can assure members that that really will work that will be ongoing, and the both of us are absolutely committed to working with the industry to see how we can help them see a future, a profitable future for them, while also protecting more areas and making our fishery more sustainable. So I'd just like to finish with these few words, and that they may surprise members, I don't know, but Jersey is the leader in the whole of the North East Atlantic in marine protection. Our marine spatial plan, our proposed marine protected areas are way ahead of what others are doing. Even next year, even with some changes that I might make, we're going to have 20% plus marine protected areas, which will pull us well ahead of the UK and the EU. We are really leading the way in marine protection, but that doesn't mean we should be complacent, and I want to continue to do more to strive towards the sustainable fishery that we've spoken about. So these 3 millimetres increase that we're speaking about here in this debate today has come into a much larger debate about the whole of our fishery and our desire to make Jersey territorial waters a leader in sustainability and sustainable fishing. And I just say, finish with this, yes, this is a small step, but this is one of a number of steps that I and we will be taking in the coming months to make our waters more sustainable and protect those fish that are in it. And with that, sir, I ask for the appel.
Thank you, Minister. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. And the principles have been adopted unanimously, 47 votes for. Deputy Coles, do the Environment, Housing and Infrastructure Screening Panel wish to scrutinise this matter?
No, thank you, sir.
Thank you. Minister, how do you propose the regulations in
Could I propose
second
them
reading?
en bloc, please, sir?
Yes. Are they seconded?
Yes, sir.
Does anyone wish to speak on the regulations? All those in favour kindly show. Thank you very much. The regulations are adopted in second reading. Minister, do you propose the matter in third reading?
I do, sir.
Is the matter seconded? Does anyone wish to speak on the regulations as adopted in second reading and third reading? Yes.
Thanks, sir. In deciding whether or not to adopt this in the third reading, I think we might also wish to consider the comments that the Minister made that this is a small step and the arguments that this doesn't go far enough. And I think what we're passing today in the wider context that I know has been touched on already, that there is a tension, of course, when making legislation like this that has been well aired between the economic and the environmental, if we could call it that simply, which is about sustainability. And I do take exception when I hear about states members being accused of being in ivory towers, when actually what they're looking to do is look at balanced the ramifications of whether or not what we're passing today goes far enough. And that would be a pertinent consideration for members in considering this, whether they can support it ultimately. Because, of course, we are in a situation where we have to support this because it is a very small step. But there is a question of whether that becomes window dressing. And I'm reminded of the fact that whenever fish stocks or shellfish stocks have been depleted, either almost in their entirety or completely, it is because the economic arguments of the day have trumped the scientific and sustainable arguments. I did think briefly of the dodo, and I know it's not the best comparison, but it is one that has a local connection. We've referred to Durrell already. And of course, when Deputy Morell said, well, the immediate problem is that these people need to put food on the table. Well, of course, in, I think it was 17th century Mauritius, the colonists did need to put food on the table. They needed to put dodo on the table. But they couldn't put dodo on the table for very much longer. The reason that's a flawed analogy, sir, is of course because one of the main reasons dodos were extinct was not because they were hunted necessarily, but because of the diseases that were brought and the animals that were brought to the island, and the fact that the poor dodos didn't know how to defend themselves. And I think that brings us back to the scallops, is that the scallops sitting there on the seabed are just sitting there, of course, waiting to be caught. What else would they be doing with their time? And I think this argument then becomes binary, sir. So I would, again, in the third reading, encourage the ministers to be bold. We either have control over our territorial waters. I'm not naive. I realise that there's a realpolitik in there. There's a global politics. But we either have the ability to say we want to do this with our territorial waters and it will apply to everybody in there. And of course we have the conversations to take people along with us. And whether it comes to small steps like this or more radical steps in the future, we can't be held ransom by bigger powers on our doorstep simply because we don't have the boldness to act. If that is the case, we might as well simply give up our territorial waters and leave the UK and the EU to legislate for us. But if we're not willing to do that, then I think we at some point have to take a step and say, no, we do have 800 plus years of not complete independence, but certainly a lot of autonomy, sir, which has been fought for and defended for over generations, and which we all take an oath of office for, which is to defend, I think, the privileges and the rights that have been given to Jersey. Not just an oath that you take, sir, but of course that all of us take on our oaths of office, and really decide what that means when it comes to defending not just the integrity of our territorial waters, but also the meaningful sustainability of our fish stocks into the future. Of course, having said that, taking all of our local community with us, because there is a long-term view here that needs to be protected for the future, not just for today to put food on the table. The last comment, sir, is that, of course, the poor octopus who are stealing the lobsters from the pots, sir, whilst that is an issue, the poor octopus, they don't have anything else to eat. They have to eat seafood. I'd suggest that we don't have to eat seafood. We can eat hamburgers, chips, carrots, and Jersey Royals, etc. So I think there is spare a thought for the poor octopus as well as the poor scallops in the future, Minister.
Thank you, Deputy. Deputy Renouf.
Thank you, sir. Just a couple of brief points. I want to thank the Minister for his positive response to the debate and to some of the points I made, and indeed the Minister for Sustainable Economic Development. I do think that there is potential to move forward together here. I would just say, though, that to those who think that we can stop here because in the end the fishing fleet have the same interests, I dispute that, and I made reference to the tragedy of the Commons. The truth is that a fisher who decides they want to help the fishing in the fishing stocks by catching fewer scallops will simply encounter the problem that always happens in this situation, which is that the other fishers can take the scallops that they have decided very helpfully to leave behind. And that is why the regulation has to apply to the whole fleet. It is because what is in the interests of one fisher is different to what is in the interests of everyone. So I maintain that we do need to think about that. I'm grateful to the Minister for reinforcing the point about the work that is going on to develop the total allowable catches, and I hope that very much that will bear fruit, and that because that is based on science, that we will have the authority to enter into negotiations when we do have to discuss this with our neighbours, because the TCA, the Trade and Cooperation Agreement, actually not only allows, but I think mandates us to take measures to protect, to make our fisheries sustainable. And therefore, armed with that information, I think we will be in a good position going forward. So all of that is simply to say that I maintain the support I gave originally for this. I think it is a very good measure, but I do also want to bolster the argument for that wider regulatory piece, because I think that is also important.
Thank you, Deputy. Minister.
Thank you, sir, and I just thank members for their further words. I would just say to Deputy Taddier that octopus are known as an apex predator, which sounds fairly serious to my mind, but they are very good at eating just about everything they come across.
They might steal my hamburger next time I'm out at the sea, sir.
But we mentioned, I did speak about how they are managing to eat lobsters and crab inside lobster pots, but of course we're also finding areas where they are eating scallops on the seabed, and they manage to take scallop shells apart, so they're pretty clever creatures. Deputy Taddier says, are we going far enough? And my answer is, well, it's always going to be a compromise. We mentioned economics versus the environment. I thought about, the stock and trying to maintain the stock versus, the possibility of non-profitable fishing businesses. And of course, Deputy mentioned that as well. It's all about a compromise. We are doing a lot of work, as well as the stock assessment. We're also doing some work to analyse the economic data of the effects on the fishing fleet of the areas we propose to close next year, because there's several £100,000 worth of product which won't be taken out of these areas once they're closed. I do believe the Deputy challenged me to be bold. I do believe we're being bold, but at the same time, I have introduced some research areas where I want more data, because all the decisions I take, I want them to be based on data and evidence. And to do that, I need more information. But the MPAs, the marine protected areas, will come in next year. Quite how extensive they are is still to be decided, but they will come in next year. I'm working with the industry. I'm working to protect areas. I'm working to protect the stocks, and I'm working to try to protect protect the industry itself. I do believe that there's a future for a wonderful, sustainable fishery here in Jersey, and at the same time a profitable fishing industry for those who still want to go out and make a living of the sea. It's a hugely traditional industry here in Jersey. But I thank members again for their great interest and participation in what could have been a very small item on the agenda today, and I certainly go away from here with members' views on the sustainability of the fishery and the sustainability of scallops in particular. Thank you, sir.
So can I ask a point of clarification?
To give way for clarification, Minister?
Absolutely, sir.
Yes, Deputy.
Yes, so when the Minister refers to the MPAs being brought in next year, but not being sure about how extensive they will be, does that refer to the further research areas, or does it refer to the areas that have been designated as MPAs and he might be considering not bringing them all in at the same time?
Minister.
So I think I can say that it probably concerns all those things that the Deputy has raised. Certainly, I wanted to do more research on some of the areas that were proposed in the original Marine Spatial Plan. That work is nearly concluded. I've also been speaking to the fishermen about other ways that we might increase the areas that they dredge, where there is little to protect. And certainly they have highlighted to me some areas that were originally identified in the Marine Spatial Plan which have very little to protect, and I'm looking at those as well. But I say to the Deputy, I am working towards 2030 and looking towards 2030 and the targets we've set ourselves for that time. And between now and then we will have a big initial step up in MPAs, but there will be a compromise solution or a compromise position proposed in the relative short term that helps some fishermen to maintain a profitable business and doesn't protect areas which don't need protection. I'm keen to protect areas that do need protecting, but I'm equally minded that I don't want to close areas to fishermen where there really is nothing there to protect, but there's still a catch that could be helping their business. Thank you, sir.
Thank you, Minister. Did you call for the appel?
I do, sir.
Thank you. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the regulations have been adopted unanimously in third reading, 46 votes for. Next item is the Draft Children Convention Rights Commencement number 2 Act, lodged by the Minister for Children and Families. The main respondent is the Chair of the Children Education Home Affairs Scrutiny Panel. I'll ask the greffier to read the citation.
Draft Children Convention Rights Jersey Commencement number 2 Act 2000. The states make this act under Article 16.3 of the Children Convention Rights Jersey Law 2022.
Minister.
This Act will bring into force the remaining provisions of the Children Convention Rights Jersey Law 2022. This is the part of the law which relates to public authorities, and if members agree, these articles will come into force on the 1st of January 2026. The Convention Rights Law, as members will know, is the means by which the United Nations Convention on the Rights of the Child, the UNCRC, is incorporated into legislation. The law is key to ensuring that children's best interests are at the front and centre when decisions are made, which may affect them. This is a fundamental provision of the UNCRC. Members will also know that the UK's ratification of the UNCRC was extended to Jersey in 2014. From that date on, Jersey adopted the convention. It took 8 years to reach the stage of indirectly incorporating the UNCRC into law, but we have achieved this milestone ahead of other parts of the UK and other Crown dependencies. We should be rightly proud of this achievement, but we cannot be complacent. The Convention's right law has been in force for ministers, elected members and assembly bodies for almost 2 years. Bringing the law into effect in 2 parts was a conscious decision. This ensured that the support was available to states members as the first cohort of duty bearers when the law was enacted. Secondly, it enabled us to reflect on how the law was operating and whether we needed to make any changes to the process before public authorities were brought into scope. The process of conducting the Children's Right Impact Assessments, CRIA, on Assembly propositions is a good example of where we have learned from experience. Members will have noticed over recent weeks that new guidance has been issued, which should ensure that no part of the impact assessment process will apply to propositions which clearly have no implications for children. This change has been implemented as a direct result of feedback from members. I'm grateful to them, as I am to PPC, the State's GREF, and my officers for their work to improve the CRIA process. Today, sir, the Assembly is asked to approve the enactment of the remaining articles of law. This will see the due regard duty extended to public authorities from the beginning of 2026. Public authorities are defined in the law, and additional public authorities can be added in due course, and indeed I hope that more organisations will be added. But for the moment, the list of organisations which will become subject to the Convention's right law is Andium Homes, Autism Jersey, Family Nursing and Home Care, Jersey Cares, Jersey Childcare Trust, Jersey Society for the Provision of a Children's Resource Centre, whose members will know this better as Centrepoint, Jersey Sport, and the parishes. These organisations have stepped up during the development phase of the Convention's Right Law and agreed to become public authorities, which means they are named in the law and have undertaken to be bound by its terms. They recognise that by committing to having due regard for children's rights as set out in the UNCRC, the most important decisions will prioritise children's best interests. So I believe the Assembly should congratulate these charities and arm's-length organisations, as well as our colleagues in the parishes, for taking this step. I hope they will be the first of many to take a similar approach to realising children's rights in Jersey. I said earlier that we cannot be complacent. There is still work to do before consideration
Yes,
of
I think
children.
you need to stop because we're no longer court, I understand, or at least may not be court. We're relying on people online to make up the numbers, but there's some uncertainty about our court.
Thank you, sir.
So, yes, you can proceed. Thank you.
Thank you. I said earlier that we cannot be complacent. There is still work to do before consideration of children's rights becomes fully embedded in our decision making. A few voices, thankfully, it's only a few, have questioned the value of taking a children's rights approach or listening to children's voices. And I've heard reservations expressed about the additional cost associated with implementing the Convention's right law. So I'd like to take a moment to address these concerns. Firstly, why should we listen to children's voices? Article 12, one of the guiding principles of the UNCRC, says that every child has the right to express their views, feelings and wishes in all matters affecting them, and to have those views considered and taken seriously. I think people sometimes get confused when we talk about listening to the voice of the child. We should remember that expressing a view does not give children decision-making responsibility, and nor should it. But children will have a perspective, and it is right that we consider this perspective when decisions could affect them. It does not mean that we have to agree with children's views, but it does mean their views should inform our decision-making. Secondly, it is not necessary to engage directly with children over every proposed decision. I mentioned earlier the CREA process for Assembly propositions have been revised to ensure that members will not have to complete even the screening stage of a CREA if they consider there are no impacts on children. Moreover, even if impacts are identified, unless the decision is highly significant or impactful one, it is perfectly acceptable to use the relevant survey reports and other published data as evidence of the children's views. We don't need to reinvent the wheel, and we should ensure the impact assessment process is proportionate to the decision at hand. Thirdly, on the question of resourcing, I would stress that support is available to all those classed as duty bearers under the law. Members will be aware of the excellent services offered by the members' resource team in the State's GREF, and support is available from the Cabinet Office colleagues too. I'm aware that parish secretaries have taken an active interest in the Convention's right law, including meeting with the Children's Commissioner to ensure that their parishes are ready to comply with the law once it takes effect in January. My officers have published CREA templates, guidance documents and online training materials, and any CREA-related queries can be directed to a dedicated email address. Finally, I would like to stress that to be effective, consideration of children's rights must be proportionate. We are not talking about preparing CREA for everyday activities or decisions that may be categorised as business as usual. But what the law does say is that if decisions affect children should be assessed for their likely impact, and this includes considering children's views. Research carried out by the OECD and UNICEF links children's participation in decision-making to more beneficial outcomes. It can strengthen democracies and aid social cohesion. It can be helpful for policymakers in designing policies that are better targeted to meet the needs of children. It has benefits to education system, and there are numerous benefits for children themselves. For decision makers, considering children's rights must be proportionate to the decision, as I've said, but not tokenistic. Impacts must be properly evaluated and mitigations put in place to counter any negative outcomes. There is a balance to be found, but we have the systems and support in place to ensure this can be achieved. In conclusion, sir, by enacting the remaining articles of the Convention Rights Law, we're taking another step to ensuring that we give careful and balanced consideration to children's rights when making decisions that will affect their lives. And this will ultimately lead to better outcomes for all our Jersey children. Jersey, sir, I propose the Act.
Thank you, Minister. Is the Act seconded?
Yes, sir.
Thank you. Does anyone wish to speak on the Act? Deputy Dublet.
Thank you, sir. I rise to celebrate this final stage in this legislation that has involved many ministers and assemblies, and it's actually a huge day for the children of Jersey. Like the minister, I want to thank the parishes and the charities who are being added to the law, especially those charities who, as the minister said, I think came forward to us to be added. I think that's very honourable. And they should be applauded. And I'm very proud that our parishes are part of this, and particularly of my own parish of St Saviour, which under the leadership of our constable is becoming more and more child friendly. And indeed we are, there's a new parish park coming before the parish assembly very soon, and all of these changes are very positive and make me feel very, very hopeful for the children of our island. I have a couple of questions for the Minister. He listed the bodies that are on, that come under this legislation. Are there any more that may need to be added in the Minister's opinion? Were there any that were perhaps under consideration or declined to be added, or that the Minister considered and then set aside? I would also like to understand how these, the parishes and the charities, how they're feeling about this legislation. Are they prepared for it, and have they had enough support in preparing for it? I believe that they have, because of course our original intention was phasing it to make sure that that support was put in place. So I believe that they would have had that support, but if the Minister could confirm that, and whether any further or ongoing support will be provided to help with compliance. And yes, so even though this does look like a small thing on our order paper, it's actually huge for the children of Jersey, that children's rights are embedded across public life and in our policy making and legislation. And the Minister mentioned careers. Now, my original intention with the proposition that I lodged, it was possibly 8 years ago, maybe even as long as 10 years ago, to have a statement on our propositions akin to what was then called financial and manpower statement. My intention was rather smaller than what we have ended up with, and it's something very detailed with the careers. And what I want to say is I want to appeal to members and to bodies that are complying with this legislation to not make it an afterthought. And I think we are quite genuinely still in the middle of culture change around children's rights. I think we're still actually quite close to the beginning. This isn't the end of our culture change, and indeed I don't think it's the end of the legislation that we need that addresses children's rights in Jersey. And I think we do need to be patient with each other and encouraging with each other, but also hold each other accountable for producing these careers, for reading them, understanding them, and using them as part of our deliberations and our decision making, because they are important. Children are important, even though they're not present in our assembly. I try to hold children in my mind when I'm making all my decisions. And I would urge members and anyone who is impacted by this legislation, and of course many of those charities, their whole reason for being is to serve the children of Jersey, is to make that consideration of children's rights something that happens at the beginning of your thought processes and not at the end as an afterthought. And finally, I am going to end by advocating for what I believe would be the next stage, and that would be full incorporation of the UNCRC. And I think that's, I was going to say Senator Mezek, but Deputy Mezek, who I know shares my passion for children's rights, as do many other members who've been involved in this along the way. And as a former children's minister, he moved a lot of this work along. And along with the current minister, I'm grateful for that teamwork and that continuity. And one of my sincerest hopes is that the next Assembly will continue in the same vein, that we won't see any sliding back, but that we will see continued progress forwards in advancing children's rights, and that Jersey will ultimately get to full incorporation of the UNCRC. So I would like to understand from the current minister, is this something that there is a trajectory towards with his current department? Is that being worked towards? If not, could he please initiate that work so that the next Assembly is ready to continue the journey in that respect? And I thank the Minister for continuing this work and for bringing this today.
Thank you, Deputy. Does anyone else wish to speak? Yes, Deputy Catherine Curtis.
Thank you, sir. The panel welcomes the extension of practices under the Children's Convention Rights Law. Children's rights, as expressed by the UNCRC, sets a framework for best practice. We must, however, be careful that we are not focused on box ticking, but have to make certain that children's rights are really considered in all matters. And I echo the Minister's comment that we must not be complacent. Jersey does not offer the same protections to children in all matters as some similar jurisdictions. Jersey needs to show it cares. It's not a good example today, for instance, that the Chamber became inchoate while debating this matter. The Minister and officers have worked hard on this, and so many charities do good work, and organisations who are supportive of children's rights are willing to play their part. The panel supports the commencement of this Act, but again states that we must not be complacent. We still have a long way to go.
Thank you, Deputy. Does anyone else wish to speak on the proposed Act? Minister.
And I thank the two speakers for their input and questions. Firstly, the parishes, I'm very pleased to see that the parishes were enthusiastic actually about being part of this and are joined by a number of charities and only one of our arm's length organisations, and I think that's an area that where I'd like to see improvement. These are government arm's length organisations, and it would be nice to see that more of them had opted to join at this initial stage. However, I would say that we didn't have anybody who actually declined in answer to Deputy Dublay's question. I think those who, all those who've joined have been particularly enthusiastic. There has been training and support, and that's ongoing with the GREF and the dedicated email address through which they can channel any issues that they have. Just like members have been supported, these organisations will be supported. The CREA, as I say, that's a very good example of how we've learnt and changes have taken place. And the way in which we now see children's views coming forward, particularly through bodies like the School Council, where children meet regularly, they put forward their ideas, and these are taken into account when we bring forward legislation and propositions. So with that, sir, I maintain the Act and call for the appel.
That has been called for. Members are invited to return to their seats.
I'm sorry, sir, could the Minister clarify a point in his speech? Apologies if I missed this, but is the full incorporation, is work already underway heading towards the full incorporation?
I don't know if the full incorporation is totally underway. However, I'm sorry I missed that because I did have it in my thoughts. We certainly aren't going to be complacent. I would very much like to be involved in taking this forward. Of course, you know, we have elections next year and it may well be somebody else who continues this journey. But no, we you know, this isn't the end of the journey. Thank you.
Thank you, Minister. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the Act has been adopted unanimously, 44 votes for.
Thank you, sir. I'd just like to thank, sorry, I should have thanked everybody, in particularly Scrutiny for the part that they played in this. And I thank members for supporting this bit of legislation. Thank you, sir.
Thank you, Minister. We now move on to the Draft Children and Civil Status Parental Responsibility Amendment Regulations, lodged by the Minister for Children and Families. The main respondent is the Chair of the Children Education and Home Affairs Screening Panel. I ask the greffier to read the citation.
Draft Children and Civil Status Parental Responsibility Jersey Amendment Regulations 2000. The states make these regulations under Article 82A of the Children Jersey Law 2002.
The Minister will propose the principles. Minister.
Thank you, sir. I'm seeking support for the Draft Children and Civil Status Parental Responsibility Jersey Amendment Regulations, which addresses an urgent and unintended consequence arising from the recent children and civil status reforms. These regulations address two connected issues. First, unmarried fathers of children registered before 2016 who subsequently married the mother gained parental responsibility through the subsequent legitimisation of their child, when read with the separate provisions in the interpretation of the children's law. However, the abolition of legitimacy removed this framework and the legal basis for this route to parental responsibility. This is clearly unacceptable and was never my policy intention. It is an unintended consequence. To resolve this issue, we will include a saving provision within the Civil Status Abolition of Legitimacy Jersey Law 2025 to ensure that fathers retain this legal basis for parental responsibility despite the abolition of legitimacy. Secondly, after 24th November, fathers in this cohort who marry or enter a civil partnership with the mother will no longer acquire parental responsibility automatically. Instead, if we do not make these amendments, they would need to enter into parental responsibility agreement, creating unnecessary complexity and administration burden for families. We'll amend Article 9C of the Children's Law 2002 so that going forward, these fathers can gain parental responsibility automatically upon marriage, now including civil partnerships, as they would have done under the previous system. This is the inheritance of a historic, inequitable system that is no longer fit for modern family life, and we are trying to put it right. The legal changes in 2016 went some of the way by allowing unmarried fathers to gain parental responsibility by registration at birth. These changes were, at that time, looking forward. The fact changes have been made incrementally over the years adds complexity, meaning multiple groups are impacted in many different ways. I would like to express my deep regret that this situation has occurred despite extensive review and multiple levels of legal scrutiny applied to the legislation. I believe originally we had over 40 areas that were impacted, or 40 other laws that were impacted, and some hundreds of amendments in the consequential amendments. We found out early last week of this current issue, and we acted with urgency and instructed officers to resolve the issue as quickly as possible. I hope that members will support our efforts by acting decisively. I would like to reassure families that this was an unintended consequence of trying to provide equality for all children by removing outdated legislation. This was certainly not the policy intention of the package of legislation, and I apologise once again to the families for this oversight. I would like to reassure members that these fathers will still have a baseline of responsibility for their children, and it will not impact their ordinary day-to-day lives. However, where issues may arise, these will relate to family breakdown and dispute. There may be issues if a child is taken out of Jersey without permission. This is why we are trying to resolve the issue as quickly as possible. This is a legal, technical correction, not a policy change. It preserves and retains rights and prevents inequality. Overall, the Children and Civil Status Law has substantially modernised the position and improved the rights of all families. I am upset for families that this oversight risks overshadowing the overall positive nature of changes. I thank members for their continued support in ensuring that we act swiftly and responsibly to protect all families. If supported by members, these amendment regulations would come in force tomorrow. Thank you, sir.
Thank you, Minister. Are the principles seconded?
Yes. Yes, sir.
Does anyone wish to speak on the principles? Dr. Dubé.
Thank you, sir. And I think this is a reminder, isn't it, of just how broad this legislation is that's now in force. And I'm not surprised that something like this has arisen, given the massive scale of the project. And I think, I'm not sure if the Minister was aware of it, when the Minister became aware of it, if he could let the Assembly know. But I do think that this has been done in the right order, and that nothing was delayed in order to correct this. What I would like to ask the Minister is, are there any further consequential amendments or any minor issues similar to this that the Minister may feel needs to be corrected in the legislation, or indeed in the policy and guidance attached to it? There's one that I have become aware of, alongside actually much joy in the LGBTQ plus community, with many same-sex parents already being able to access registration for both parents from Monday this week. And there has been a huge amount of joy and celebration in my community with those appointments already being used by some parents. But an issue that has been identified to me is that when parents are registering their children with a new name, they aren't then able to gain access to passport registration. So if the Minister could speak to that other consequence, and any others that he thinks may need to be addressed, either with the consequential amendments or changes to policies and processes.
Thank you, Deputy. Does anyone else speak on the principles? Yes, Deputy Catherine Curtis.
Thank you, sir. There was an oversight in the drafting of this legislation, which is not surprising. It's extremely complex legislation which impacted on many other laws. The panel received a briefing and raised concerns on practical issues which have been addressed, and addressed very fast as well. The panel supports the Minister in putting this right and asks the Assembly to keep in mind the overall aims of the Children and Civil Status Law, which has been such good news for so many families.
Thank you, Deputy. Does anyone else wish to speak on the principles of the matter? No. Minister.
Once again, thank you for those who have spoken, and in particularly for scrutiny for their support in allowing us to get this through so quickly. In answer to Deputy Dublay's question about when did we become aware, it was actually a week Friday, so just 10 days ago, when officers and lawyers were looking at this once again, and somebody thought of this scenario and realised that there had been an unintended consequence. And so we've acted very swiftly on it. And of course, the law itself came into place on the 24th. So it's only a matter of a few days where there could be an impact if we pass this today. So I thank everyone for their input and for those questions. I'm just looking at the issue of the passport registration, and I will ask for that to be looked at. I think possibly there's been a possible oversight there, but I think that's more procedure than the law itself, so that we can get the process coordinated so that the registration and passport can be done at the same time. With that, as I've said, if the amendments to the regulations are agreed by the Assembly, this will quickly rectify this parental responsibility issue for unmarried fathers who registered before 2016. As we said, it's a legal correction rather than a policy change. And once again, I do regret that with the need to bring this to the Assembly, and that it wasn't spotted earlier, but there was so many impacts from the new legislation that it was almost inevitable that perhaps one would slip through. And of course, we'll be keeping an open mind as to whether there might be something else. I hope not, but if that does occur, then again we will act as quickly as possible. So with that, sir, I maintain the principles.
Thank you, Minister. Is the appel called for?
The appel is called for, sir.
It's been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. I announce the principles have been adopted unanimously. 44 votes for. Deputy Catherine Curtis, does your panel wish to scrutinise this matter? Okay. Thank you very much. Minister, do you propose the regulations in second reading?
Yes, sir, on block. I would like to thank members for their support and reiterate that it is regrettable that we have had to lodge this, but necessary. And as I say, we have acted as quickly as possible. Sir, I maintain the regulations.
Thank you. Are the regulations seconded?
Yes, sir.
Thank you. Does anyone wish to speak about the regulations in second reading? Those in favour of adopting regulations kindly show.
Appel, please, sir.
The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. The regulations have been adopted unanimously. In second reading, 45 votes for. Minister, did you propose the regulations in third reading?
Yes, sir, I do.
Are the regulations seconded?
Yes, sir. Yeah.
Does anyone wish to speak on the regulations as adopted in second reading in third reading? Is the appel called for?
It is, sir.
The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members will now cast their votes, I ask the greffier to close the voting. I can announce that the regulations have been adopted unanimously in third reading, 44 votes for. The next item is breaches of the Code of Conduct review of standing orders lodged by Deputy Kovac. The respondent is the chair of the Privileges and Procedures Committee. An amendment has been lodged by Deputy Scott. Deputy Kovac, are you minded to accept the amendment of Deputy Scott?
Yes, sir.
Members content to take the proposition as amended. I ask the greffier to read the proposition as amended.
The states are asked to decide whether they're of opinion to request the Privileges and Procedures Committee to review, with a view to amending, all standing orders in relation to breaches of the Code of Conduct. Such review to include, but not be limited to, consideration of current procedures for the handling of complaints and disclosure of personal details, disqualification mechanisms, and varying lengths of suspension, paid and unpaid, and to present a report to the Assembly no later than 31st of December 2026 with its findings and recommendations.
Deputy Kovac.
Thank you, sir. This proposition asks the Assembly to request the Privileges and Procedures Committee to review all standing orders relating to breaches of the Code of Conduct. The purpose is straightforward: to ensure that when misconduct occurs, our system responds in a way that is fair, proportionate, and clear. Recent events have highlighted that our current approach does not distinguish clearly enough between serious and less serious breaches, nor does it always provide guidance on what the proportionate response should look like. That lack of clarity risks unfairness, inconsistency, and reduced public trust. The proposal doesn't limit on what the review could include. However, I believe reviewing a recall mechanism process as well would also have its merits, allowing us to understand how it might work in practice in Jersey and whether the right safeguards could be put in place to prevent political misuse. Other jurisdictions, including the UK, have used recall to hold elected members to account in a fair and controlled way. If a well-designed system can strengthen public trust, it is only responsible that we examine it, both to understand benefits and consequences. Again, it's up to the PPC in what way they revise this. This review will therefore aim to look at the full range of sanctions, from minor matters to the most serious, and ensure that any response is matched to the actual level of misconduct. Importantly, it will also consider how to prevent misuse or abuse of the system, so that complaints and sanctions cannot be applied unfairly or used for political purposes. Deputy Scott's amendment expands the scope of the review to include how complaints are handled and how personal information is disclosed. I welcome and accept the amendment because it strengthens the work we are asking PPC to undertake. Reviewing the complaints process and the protections around privacy is important if we want a modern and fair framework that gives confidence to everyone involved. I also want to thank the chair of PPC for our discussions and for indicating their willingness to accept both my original proposition and the amendment. By asking PPC to look carefully at our existing rules, consider best practice, and bring forward balanced recommendations, we can ensure that any future changes are robust, practical, and able to maintain public trust. I hope members will support the amended proposition so we can modernize our standing orders, promote accountability, and strengthen confidence in our democratic process. Thank you, and I make the proposition.
Thank you, Deputy. Is the proposition seconded?
Yes, sir.
Deputy Scott.
I think, okay, thank you. Sir, I would like to thank Deputy Kovac for accepting my amendment and the Privileges and Procedures Committee for their comments. There have been two recent occasions where members have not been fully aligned with the PPC in supporting its own propositions for enforcement of the Code of Conduct. The reasons for differences have not been reported in mainstream media, while the bringing of amendments to the propositions risked protracted and unsavoury debate. We cannot expect total alignment on all matters regarding enforcement of the Code, but the more we can agree on matters in advance, the more alignment we can have. It is important that clear policies and procedures are developed and published by the PPC in relation to the whole process of dealing with the identification of, consideration of, and enforcement of breaches of code of conduct. It is significant that we should be debating this matter after approving changes to the disciplinary and complaints handling procedures for the police. Statistically, the police is an institution that is more trusted than the State's Assembly. And I believe that we can learn from some of the principles set out in the regulations we approve today without adopting the extent of their detail. Trust in the decisions we make as an elected body or as part of a body constituted under our standing orders depends on enforcement of our code of conduct and transparency and consistency in the way we apply it and handle complaints. The PPC will be serving both the public and States members by developing and publishing supporting policies in these areas. I have mentioned in an earlier debate that being the subject of a complaint can be a lonely place. The proposed code of conduct that has been lodged by the PPC seeks to support confidentiality to assist investigations by the Commissioner for Standards. It will be helpful for the PPC to reflect on the extent to which it is supportive to the subjects of complaints, to be allowed to share complaint details with third parties such as family and the equivalent of police friends. Concepts such as confidentiality and anonymity of the personal details of complainants also needs to be addressed. It is important to have a policy that seeks the right balance between transparency and the human right of privacy. Parliamentary privilege regarding the disclosure of personal details needs to be used judiciously, of course. Parish public authorities and public service ombudsmen generally are constrained from publishing details of complainants under data protection principles. And public disclosure of personal details could reduce enforcement of the code of conduct. Fear of potential retaliation could deter the making of complaints. So could mishandling and lack of communication regarding the handling of complaints. It is important potential complainants are made aware of the processes and methodology of complaint handling before they have brought complaints, so that they know how those complaints will be handled, when the outcomes will be communicated to them, and the reasons for those outcomes. Sir, I thank PPC members for the time they have given me to articulate these concerns in a recent meeting with them, and hope States members will support this proposition as amended.
Thank you, Deputy. Chair of PPC.
Thank you, sir. I hope members will have had seen the comments from the Privileges and Procedures Committee. The PPC has accepted the proposition and the amendment, as these are matters that we're already looking into. In light of practical experience during this term, the PPC concluded it would be beneficial to review the provisions in standing orders that deal with sanctions for a breach of the Code of Conduct. We have also been considering the disqualification provisions under the State of Jersey law. Both Deputy Kovacs and Deputy Scott have engaged with the committee and provided their feedback to us, for which we are grateful. As Deputy Kovacs has highlighted, adoption of this proposition will formalise an ongoing process and provide a clear expectation to PPC that it report back to the Assembly with its findings. The current committee will aim to complete its work during this term, but the proposition from Deputy Kovacs allows for the review to continue until the end of 2026. If work does carry on into the next term, the current committee cannot predict, of course, what the next PPC might conclude. It will ultimately be a matter for this Assembly to determine what system should be in place. Thank you, sir.
Thank you, Chair. Does anyone else wish to speak on the proposition? Deputy Kovacs.
Thank you. Thank you to members for their contributions. And I just want to very briefly underline again why this review is necessary and why the proposition with the amendment deserves support. Our current system needs clearer definitions of what constitutes a serious or a minor breach and clearer guidance on the appropriate response in each case. This is essential to ensure fairness, consistency, and transparency for members and the public. This review is not just about sanctions, and disqualification doesn't mean just recall. It is about making sure our entire framework works in real life. and there are clear examples where it currently does not. For instance, losing British citizenship for any reason could automatically make a member ineligible to sit, yet we have no guidance on how such a disqualifying situation should be handled. Bankruptcy is another example. A member previously lost their seat because of it in 2014, even though bankruptcy does not always reflect their own wrongdoing. Members can search the Pittman Couple case if they want to see more details. I have personal experience on how easily such circumstances can arise. My family business opened in January 2020, with most of our savings invested in it. 2 months later, lockdown began. Without government support, we could have gone under, and under current rules, I would have been disqualified through no fault of my own. This shows why our rules must be proportionate and reflective of the complexities members may face. The amended proposition also asked the PPC to review how complaints are handled and how personal details are shared. People must feel safe coming forward, and all parties involved must have confidence in a fair, balanced process. I once again thank PPC for their engagement and support, and I hope members will back this important work. Thank you, and I call for the appel.
Thank you, Deputy. The appel has been called for. Members are invited to return to their seats. I'll ask the greffier to open the voting. Four members have cast their votes. I ask the greffier to close the voting. I announce that the proposition has been adopted. 41 votes pour, no votes contra, and 1 abstention.
Deputy Morale abstained.
That concludes public business for this meeting, and I ask the Chair of PPC to propose the arrangement of public business for future meetings. Chair.
Thank you, sir. The arrangement for public business for future meeting is as per the consolidated order paper. Members will note that P94, Management and Maintenance of Holiday Parside, has been added, so that will extend the meeting slightly. Obviously, it's the proposed budget government plan coming up. We will be starting at 9:30 a.m. on the 8th, and I would expect that all continuations days will be used. I'm expecting there may well be a continuation, an evening continuation on the Thursday evening, which I have already forewarned members about, but there may be others depending on progress that is made. Therefore, I propose the order of business, sir. Thank you.
Thank you, Chair. Are members content to proceed as suggested by the Chair of PPC? And are members now content to adjourn until the 8th of December at 9:30? The States is adjourned until that day.
Last chance to sign up and pay for